Hello everyone, I'm Luciano Oliveira from Oliveira Lawyers. I am a Brazilian attorney also licensed in Texas and California, and today we're going to be discussing about how lawsuits work in Brazil. So the first distinction between Brazil and other countries is that Brazil runs over civil law. Yes, civil law is different from common law, which is the legal system for countries such as the United States. And because Brazil operates under civil law, you're going to have some distinctions in terms of how decisions are made and how the lawsuit dynamic works in Brazil. The first point is that there is no stare decisis in Brazil, meaning that while in the United States a judge must follow a prior decision very narrowly, in Brazil there is more discretion in terms of how a lawsuit is going to be decided. That's one of the main features of the civil law system. And expanding on that, a Brazilian judge, as a consequence, is going to have more say in terms of how to decide a specific case. Of course, you still have the ability to bring a case to appeal if you don't agree with the final decision for a case, or even an intermediary decision from the judge in your case, but still, there is less ability for an attorney to foresee what an outcome to a case would be. This said, of course, there are certain situations in which we can clearly tell if a certain path of action is going to work or not. Second distinction is going to be on the discovery side. In the United States, for instance, there is a lot of discovery done between attorneys and their clients, meaning that there is little interference by a judge in the discovery procedure. In Brazil, on the other hand, there is basically no discovery whatsoever unless a judge is participating in the proceedings. In other words, if you want to depose the other party, for instance, you're going to need to first ask for the judge, and then the judge is going to schedule a hearing in which the judge is going to be participating in the deposition itself. As a consequence, the discovery stage in Brazil may take much longer and it may have a lot of friction, and attorneys are going to have less discretion in terms of how to conduct the depositions. That's going to be the same thing for subpoenas, for instance. In California and Texas, attorneys are going to have plenty of discretion. In Texas and California, for instance, attorneys can basically send subpoenas to several third parties in order to obtain evidence that's going to be relevant to a case. Guess what? In Brazil, attorneys do not have such power. In order to subpoena a third party, they are going to first ask for the judge to authorize, and the judge is going to actually be the one sending an order to this third party to hand over relevant evidence to the case. There is another difference between the two systems, or how Brazilian system works, in a sense of costs. So in Brazil, once you file a lawsuit, most of the cost commitment is going to be already incurred. In the United States, it's the opposite. Like, you usually spend very little to file a lawsuit. It could range from a couple of $100s to a few $100s, but at the end, the real cost is going to come along the way, meaning that the more work is done by an attorney, the higher is going to be the bill that the client is going to be paying. On the other hand, in Brazil, the cost associated to the attorney work is not as steep as you would see in the United States. However, there are many substantial costs a foreign party may incur when filing a claim in Brazil. Because when you file a claim, you're usually going to pay a percentage of how much you are trying to obtain. In São Paulo, for instance, you're going to pay 1.5% of the claim amount. And on top of that, it is somewhat common for a judge to ask for a security deposit from this foreign party to allow the foreign party to participate in a lawsuit in Brazil. And unfortunately, such security deposit can be as high as 20% of the overall cause amount. Another distinction is going to be in terms of timeline. In the United States, most cases are going to be resolved in less than 3 years, either in Texas, California, or many other US states. In Brazil, unfortunately, it's not rare for a case to take over 10 years to be resolved. And one of the most problematic types of cases in terms of timeline are going to be probates in Brazil. For probates, whenever there is a dispute among participants of the probate, for instance, family members, cases may take well over 10 years. I've seen in my career some cases taking actually decades to be resolved. And for foreign parties, there are some specifics that do not apply to the Brazilian party. One distinction is the one I told you about the security deposit. A Brazilian party litigating in Brazil is not going to need to present usually a security deposit because it's a local party, and the judge knows that if the party loses a case, the other side is going to be able to recover by pursuing assets from the losing party in the country. However, for a party that's outside of Brazil, it would be very costly or even impossible for the local party to go after the foreign party for compensation. Another distinction is going to be the need for legalization of foreign documents to be used in Brazil. So you are not going to be able to simply present documents from abroad and expect a Brazilian court to accept those documents as is. It is very common for the Brazilian court to ask for such documents to receive a legalization through the so-called Apostille system. And after that, once the document receives the apostille, additionally, you may need, or you probably need to hire a sworn translator to do a special type of translation from the foreign language into Portuguese through the process of sworn translation. So this was an introduction to the topic of how litigation works in Brazil. Make sure to watch our other videos to know about those aspects in more details. And don't forget to download our ebook, The 7 Things You Must Know When Handling Disputes in Brazil.